All right, this is a contempt hearing for failing to, it says pay for daycare and long distance
Travel.
travel
Yeah.
expense. I think that's really what the focus is
Yeah.
in this
Yeah.
case.
They live in Florida now. So she was supposed to come home and she didn't make it home for Christmas. And he did not buy her ticket for spring break. And I kept sending him messages. Hey, I found a ticket for this much. And he ignored me and then was gone the whole week before she was supposed to leave and was ignoring our daughter. So I went ahead and made arrangements and I ended up paying a lot of money for a ticket that he's supposed to pay for.
And she did come home then during spring break.
Yes, she came home for spring break. Yeah, I hadn't seen her for like 8 months.
Okay. Mr. Miranda, part of the response was the problems you ran into at Christmas time, and it doesn't sound like that's an issue today. The issue really we'll focus on is the spring break travel expenses. So if you want to address that, go ahead.
Your Honor, I fully agree. I had not made arrangements for the spring break travel. Hope's grades were in jeopardy of her not graduating. The expense that I have gone through with a senior and all the graduation stuff that's all involved in everything. Honestly, sir, I just ran out of money, and it wasn't. I never received anything from Marlene tell me about ticket prices or anything like that. She may have sent it directly to our daughter because that's pretty much how we communicate is through our daughter and everything. But I had also told Hope that I plan to, after she graduated, send her home for a longer period of time over the summer. And I had to actually travel that week for work. So it was just a bad time overall. And honestly, Your Honor, I just ran out of the money. As Marlene had mentioned, a very expensive plane trip. I had spent the money to get her into the, during the Christmas time. And unfortunately, due to bad weather, the trip was canceled there. And I couldn't afford it, sir.
Ms. Height, any comment on this issue?
Good morning, Your Honor. I did have a phone conversation with this sweet girl, and she was this was shortly before spring break, and she reported to me that she'd not been able to see her mom at Christmas, and she wanted to see her mother. And the extent she was really basically expressing her disappointment, which I fully understood, because at the time this case was settled, it was very clear what the expectations were. And Ms. Wanzer had been assured that this was what was going to happen. And so I was disappointed for everybody involved that it didn't happen. I understand that expenses come up, and the flights around Christmas time, it sounds like, was a nationwide nightmare. I wish something could have been settled sooner than spring break, and I'm very happy that they got to have that time. But I guess my only real cogent comment for you this morning is that I did speak with her, and she definitely wanted to spend some time with her mom.
Okay.
Your Honor, may I?
Sure, go ahead.
Basically, John has stated that, he's financially extended and everything, but Hope was only home a few days and he went and bought a brand new car. So that to me does not sound like he's very financially strapped. Also, he knew spring break was coming and he could have put a ticket on layaway. He's an adult. He knows how to do this, and comes, also what's in the papers that I had mentioned is that he's supposed to, he offered and said that he would help me with accommodations to come if I flew out to see Hope. I have a ticket. I'm going out for her graduation. That was what she wanted. So that's what I'm doing. And he has offered no help with that. And that was another over $900 ticket. So I feel like he should have to help me with that. And that's just, for compensation for him not getting her in December. Now, the thing about the December thing is he made the arrangements after she'd been out of school for 3 days for her to leave Christmas Eve. And all of that could have been avoided if he would have had the ticket ahead of time and she would have left earlier on the day that she was supposed to. So, the weather thing happened, but that's not what's supposed to happen. She was not supposed to be flying out late night on Christmas Eve, for crying out loud, and then had her returning home on New Year's Eve. Do you want your daughter traveling alone on those days? I don't want my daughter traveling alone anyways, but come on, it's a little bit out there. So, John waited till the last minute. That was end of story. Just like he did with this one too. So I've said my piece.
All right.
And now
Again,
we don't have to worry about it. She's 18.
all right, let me tell you how I'm gonna rule here. And again, the amount requested doesn't relate to anything at Christmas. It's disappointing that the daughter wasn't able to visit at Christmas, but I think some circumstances that Mr. Miranda could not control occurred. Also, Mr. Miranda, I think, has been honest about his situation today. Both parties know that the order is very specific, that Mr. Miranda is to pay for a trip at spring break and a trip at Christmas. He did not pay for the one at Christmas, and despite the fact he indicates he couldn't afford it, he's still obligated to pay that. So I'm gonna find contempt. I'm not gonna sign this order as it's presented to me, so I'm gonna go through and indicate the changes on it. So Mr. Miranda will be responsible for a payment of $902.90. I'm not gonna award the interest that's being requested.
In your honor, I mean, it is stated in the papers that he's supposed to, he offered himself to help me with accommodations if I fly out there to come see our daughter. And I have purchased the ticket.
Okay, well, that isn't part of this motion right now. So one of the things that I can only do is deal with the motion that's in front of me. So the motion in front of me is, what do I do about spring break? And it's appropriate that Mr. Miranda reimburse you for the airline ticket. Just hang on a minute here. I'm gonna strike the part that indicates that it was in bad faith. I don't find it was in bad faith, but he's still responsible for minimum civil penalty on a contempt is $100. So I am going to assess that. So I've gone through the order and indicated the amount owing is $902.90. I've assessed the $100 contempt penalty, and I've removed the bad faith language. And with that, I will sign the order.
Thank you, Your Honor.
And so, your honor, what is the link that he has to repay me for this?
Mr. Miranda, do you have a time frame when you can make that payment?
I would ask for 30 days, Your Honor.
All right, so on number 11, where it indicates contempt can be corrected,
Thank you.
I will say pay within 30 days.
Thank you.
Okay. All right, thank you, your honor.
Mr. Bowers,
Thank you,
is
Ann.
Ms. Rodriguez here?
No, I actually have a letter from the Skagit County Sheriff's Department.
Okay,
I tried to serve her 9 different times, and she was home and did not answer the door to get served from the sheriff. So I need to get, like, I guess I'm asking for the permission. They said I could ask to see if I could just mail it to her or hand it to her in person. So that's what I'm asking for.
okay,
And I have the copy of the sheriff's log here.
all right, so that will likely be granted, but there needs to be a separate motion made to allow you to serve by mail.
Okay.
And you need to put in a declaration of all of the efforts that have been made. And what you would probably want to do is attach the letter from the sheriff's office.
Okay.
And then one of the judges here will sign off on you being allowed to serve by mail. The order gives the specific address that you want to send it to.
Okay.
So put that together. You can probably get the form from the clerk's office.
Okay.
Also, once you serve it by mail, you need to submit a declaration saying that on such and such a date, you sent it by mail, and it needs to be sent regular and certified.
Okay.
Okay. Once you do that, I'll put a hearing out for probably 3 weeks here.
Okay.
If that gets done, then we can move forward if there's no response.
Okay. And is there no way to make it an in-person case, or does it always have to be Zoom?
Well, right now I'm not in a courtroom. I'm in what we call a virtual courtroom. So at this point, it's going to have to be on Zoom.
All
I
right,
know, I know you're at the courthouse in one of our Zoom booths, but it's gonna have to be on Zoom right now.
okay, it's just because I was kind of, well, never mind. She lives 4 hours away and she's getting lucky by not having to come all the way down here. So I was hoping we could do non-Zoom, but that's okay.
Let's set a review in this case for May 11th,
Okay,
and that should give Ms. Rodriguez enough time to respond.
so I just need to go to the clerk, get the paperwork to serve her by mail and get that done.
Yeah, it'd be a motion to serve by mail,
Okay,
and they should be able to provide that to you, or at least tell you how to get one.
Okay.
And you'll want to get the motion and the order to submit to the court.
Right.
It'd be a $30 fee to do that, but if you do that today, certainly by next week, you'll have that order. Let me go to you. I know you were in court
Okay,
with
all right,
Judge
thank you very
Evans recently, but I think we're here for child support at this point. Is that right?
Child support, and then the Talking Parents app. We had court 3 weeks ago, and you ordered Christine to file 3 months of pay stubs, indicate wages garnished, and to submit a declaration regarding the name of the app that she is attempting to use to communicate. And we held it over to today.
And I didn't see 3 months of wages, but I did see some wage statements, and it did show a garnishment on that. Did you see that?
I'm the one who submitted that.
Oh,
She
you
didn't, yeah, she didn't submit anything to the court.
Okay.
She sent me a copy of the interrogatories for the trial that she missed on Monday. And in that included a mismatch of pay stubs. There are partial garnishments happening, which is part of it. It looks like they're garnishing around $180 a month, which fits with about what I've been getting. It seems to be hit and miss, but her income shows that she absolutely should be garnished more than that.
Actually, I think it's $180 every 2 weeks. So the pay periods go from 129 to 211. The other one.
Right. I did see that in the January statement, how there was 2 of them. However, I received 180 in January and then another 180 in February. So if the garnishments are behind by a week, any way you look at it, I'm not receiving it. And I'm not receiving it in a way that it's even close to what she should be paying. $180 a month instead of $608 a month is not sufficient, especially when she's taken 2 vacations so far since we started these proceedings 3 months ago.
Who are you receiving the money from?
Division of Child Support.
Okay.
And you'd asked me to call Miss Looney's office to talk about how we get onto the monthly child support contempt docket. And I have information on that too, if you want it.
All right. I did talk to her yesterday myself, but why don't you go ahead and discuss what you found out?
I learned that it's the caseworker assigned to person who is supposed to be paying. The caseworker is determined by the address of Christine. So, and then it's that social worker, when they have exhausted what they call all means, that then they can make a referral to the court. But that sounds like it would be in either King County or Pierce County, not here. They did suggest that I continue to do it privately, that I'm likely to get a swifter and stronger response from the court. But I could certainly follow up with her social worker and ask him to refer it to the Pierce or Tacoma, King County, so that they could start, threatening jail time or whatever it is that they do. So
What is, and I'm sorry, I don't know this, but what is the monthly child support that's been ordered at this point?
608 plus daycare and medical at 53.3%.
Okay, so even at $360 a month, we're still about 200 some dollars shy, $240 shy of that.
Right. And it looks like she picked and chose the pay stubs to send me that were garnished, because there's a lot of missing ones in there. Like I didn't have any for February. I had 2 for January. There was like a December one, an October one. Like it was really hit and miss what she sent me. And honestly, you look at it and she is working 80 hours a week plus overtime at $18 an hour. I mean, her monthly income for January was $3,200. There's no reason out of $3,200 that she's only sending $180 in child support. If her employer is not garnishing the full amount, it is her responsibility to make that up.
What amount are you asking for today? Have you calculated that?
Your Honor, she's behind by including the judgments by like almost 50 grand. I would take anything at this point. I mean, we have a $34,000 judgment that she hasn't paid a dime on that's been accruing interest for a year and a half at a rate of $334 a month in interest. I just don't. The dollars I'm looking at are so overwhelming. I would love it if she made $1,000 a month payment, the $608 a month for child support with an additional $392 a month to start on the arrears would be a great place to start.
Ms. Latos, any response?
Yes.
Go ahead.
I am currently looking for a better job, have a good job offer to hopefully get some money. Right now, my bank account is less than $200. I truly do pay what I can, but I really do need to find that better job. I'm not even getting 40 hours a week currently. So that's where I'm at. I gave all the pay stubs I had. I just found everything I could find and put them in chronological order and copied them and mailed them. Your office wouldn't receive them directly, so I had to certify mail them to you with a copy of my screenshot showing a couple different parenting apps that I could download that I had been exploring. Again, those were sent certified mail. I'm currently in Nevada trying to find a job, so I don't have access to my Washington Post for the past couple days, but I'll be back within the week.
I realize she claims she's in Nevada looking for a job, but sending papers from Las Vegas indicates she's on vacation.
I'm a poker dealer. I'm trying to find a poker job for the World Series. I got a job offer from Caesars, but I have to wait for all the background information to come through.
All right. You acknowledge that the current child support order says $608 a month.
That is correct. I missed
$304 per child, right?
Right. I missed that trial date. I wasn't able to represent myself. Melissa got everything she wanted at that time without any type of negotiations. She just got her way.
Well, but you weren't present.
Yeah, I know. I wasn't present. I was in the courthouse, but I couldn't get on Zoom. So at the time, I was just out of luck. So I didn't know how to proceed from there. I really don't know how to proceed from here.
And you have not worked out using Talking Parents yet as an app to.
I haven't. I get in there and it's just blank. I don't.
Have you gone to anyone to try to make it work?
Gone to anyone? I've sent a request.
Have you gone to a computer store or?
Oh no, I haven't tried that. No, I haven't. When I get back home, I have actually a friend that does a computer store.
Well, this is the, what, 5th month that we've been discussing this. It seems to me that should have been done long before today.
Okay, I apologize.
Your Honor, the first time she was held in contempt for this in the same month 2 years ago, she stated in her declaration that she was going to see this same friend, his name is Nate, in Tacoma, who works in IT, and that he was going to help.
Nate passed away.
The reality is I'm very sorry to hear that. The reality is she keeps saying she's going to do it, but not doing it. It's been 2 years this month.
I know. That's come up. Just give me a moment here. I want to look at my last contempt order. All right, I think my last contempt order was on February 9th. And I ordered past due child support of $3,135. past due medical of $563.49, a civil penalty of $500, and no attorney fees. Excuse me, a daycare expense of $1,165.94. Not sure what all that adds up to. We're back here today on two issues, and that is the full child support has not been paid. I do acknowledge there's been payments through a garnishment, but those do not completely satisfy it. And secondly, we're still dealing with a failure to use the parenting app. And Ms. Latos has been given multiple opportunities to try to get that to work. And it sounds like she hasn't really asked anybody to assist her to do that. So I'm going to find that there is contempt both on the parenting app and on the child support. Ms. Hiltz, I want you to prepare an order. I don't have one in the file. So the order would indicate whatever child support is due since February 9th, less any amounts paid through a garnishment. And the civil penalty, we did $500 last time to try to get the parenting app in place. That didn't work. So the civil penalty this time will be $750.
Is there a time frame on paying those? Like, she's gotten a lot of judgments and penalties, but I've not ever actually seen any of the money from any of them, nor have I figured out what I do to get it. Is there a time frame on those? And then is the next step then to file another contempt for not paying the contempt?
Well, I don't know that you can get a contempt on a contempt. And what you have is a judgment. And so you can enforce that through ways that judgments are enforced. This is going to be a little bit more complicated because Ms. Latos is working in Nevada. So you'd have to have a judgment entered in the Nevada courts. And then whatever tools Nevada allows, garnishments or some other ways, could be utilized at that point. Okay. I know these judgments are building up, but the tools available are the tools to collect a judgment.
Okay, that's fair enough for me to figure out.
Okay. So if you prepare that order, that gets us then to April 13th. I want to set a review in this case for a month from now, and it's to specifically to check in with Ms. Latos as to her work status. And if you do have a new job, then I want to make sure that Child Support Division knows about it, and I want to make sure that Ms. Hiltz knows about it. Okay. So
is there excuse me, I'm sorry
Go
to
ahead.
interrupt. Is there somebody I can contact when I get my first paycheck so that we can expedite this process to getting it, so it doesn't push out several months?
I would call the Longview Child Support Division.
Okay.
You could talk to Ms. Looney or Ms. Powers. And
That's 2 O's, Looney.
yes, or Ms. Powers,
Okay.
and give them the information, and then they will, they'll take it from there in terms of
Okay.
putting another wage garnishment in place.
Excellent.
I'd like to set a hearing then for May 11th. That's a Thursday at 9 o'clock. To just check on the status of Ms. Latos' employment at that time.
And one more question.
Sure.
Since I'm not objecting to her going to college, this in no way restricts her from getting housing and getting to college, correct? She can go to Massachusetts and get her education.
Judge Evans approved of all of that.
Perfect,
at the
perfect,
hearing
okay.
that you did not attend. So she's
I showed up on Thursday
okay,
instead of Monday.
she's clear to do all of that.
Your Honor,
Excellent.
And let me just maybe take that one step further. That also does not change the orders that apply to you. Okay. Ms. Hiltz?
Understood.
Okay, Ms. Hiltz?
the 11th, I have a conflict.
Okay.
Can we go the 4th or the 18th of May?
Do you think you'll have the new job by the 4th?
Oh, I sure hope so. I don't have enough money otherwise.
Okay, all right, then let's make it May 4th at 9 o'clock. May 11th was not a hard and fast date. It was just going out a few weeks. All right,
Perfect.
we'll see you both back here then on May 4th, okay?
Okay, have a great day.
All right, thank you. We're here today to look at the test that was ordered. And one was provided to me, and I believe it indicates that it was negative. And that was a note that Ms. Height sent to me with that test, and I see it was also filed with the court. And so let me look at my notes here. Do we still need a domestic violence evaluation done then at this point? I think that was ordered prior, right?
Yes, Your Honor, if you're asking me, that was part of it, and unfortunately, those are slow moving.
I've heard from other cases I've had. And that, Ms. Miranda, what are you doing in terms of the domestic violence evaluation?
Yes, Your Honor. So I've been contacting them at least once a week. I made sure to contact them this Monday with the hearing impending this week. The most recent information they asked for me was a release of information document to be able to review any police reports and things like that related. So that has been signed and provided to them. At this point, they're still saying there are 5 cases ahead of mine. I've never been involved with an evaluation or anything like this before, so it's also frustrating and news to me how long it does take. So the most recent information I received on Monday, and again, this is all via either text message communication that they're giving me or email. I've only spoken to someone on the phone once or twice, even calling and leaving voicemails myself. I'm not sure why it's done in that manner. Is that they did receive my release of information form, and they are waiting on Kelso Police Department to get those records. And I'm just essentially still in queue for the evaluations with the other people that have been ahead of me.
And they haven't given you a time frame when they think this can be completed?
Every time I ask them, they essentially just give me the update of how many cases are ahead, and they just tell me, and this is where yours is at, waiting. And then that's what they said, was waiting for the response and the paperwork from that police department. I'm a little bit confused of why they wouldn't have requested that before, when they requested the other documents to be filled out and things by me. I kind of wish they would have, so that this could have been progressing already, because, you know, with having you file document requests and sign those type of forms, it does take time for all the correspondence. So I'm not exactly sure. I'm just following up and doing what I can on my end to get this to progress as fast as possible. As I shared at our last hearing, you know, this is causing me to have to miss out on time and be waiting. And, you know, I have, you know, especially my son expressing that, you know, Mom, it's not fair. I don't understand why things can't be part-time. I try to avoid, you know, that type of conversation with the children and not bring those things up, and just keep things as, you know, neutral as I can to then be there for them. But, you know, it's being expressed that they, or he specifically, as this case is pertaining to him, really wants to be with me. I just make myself available as much as possible, offer any time that I can to, you know, help with work schedules or anything like that. I was allotted some more time during spring break with him, which I appreciate, with his dad working, and we had a lot of good time spending that time together. So, you know, I just want this to progress as fast as anybody does, to have that time with them.
You're seeing him the first and third weekends at this point?
Yeah, still that.
Mr. Estrada, how are things going from your perspective?
Things are going really well. The response from his school has been really good. He hasn't been tardy at all since he's been with me, and his teacher has seen him progress really rapidly. And there's, behaviorally, everything has been great. He's, seems very content. I did decide that it was in his best interest to spend some time with his mom during the spring break because the current orders don't have it for any holidays. And my original orders that I submitted to the court, I wanted to do alternating holidays because I think that that's fair. And I feel the same way. I mean, I just want this to progress as fast as possibly. Obviously, I want to, do everything that the court wants to be done. And I'd like to have the opportunity to put my input in on a domestic violence evaluation. So just looking forward to them contacting me so they can get my input.
And Your Honor, if I may, when I checked in with Ms. Height about making sure all the bases were covered and my things were submitted to the court in reference to the UA and that test, I had expressed there as well that kind of where things were at to just give, as much update as possible. And again, just saying that these things are slow moving. Yeah, I'm just as frustrated. I don't think that has anything to do with anyone involved as much as being at the mercy of the time of how things are being handled with the evaluation.
Ms. Height, any comment?
Well, I share the frustration of these parties and many other parties in many other cases. This just seems to be the nature of this type of evaluation. I do think it's critically important to get the evaluation done. It was one of the major presenting issues of this case. And so along with everyone else, I'm hoping for a good resolution, and we're just kind of in a wait and see mode. I'm very happy to hear that the kids are doing well. And I think that's basically the only input that I have.
You think we should keep the current visitation schedule until we get that evaluation?
I certainly do, Your Honor, yes.
I'm very happy that the UA test came back negative.
Yes.
I'm very happy that Ms. Miranda is taking, I think, significant steps to get the DV evaluation, and your frustration is not singular. That there are many people, as Ms. Height indicated, that share that frustration. That's probably unfortunate. There probably needs to be more capacity to do these evaluations in our area. I'm going to leave the same visitation schedule. However, if the parties, and this would really be driven by Mr. Estrada, if the parties want to create more time between the children and Ms. Miranda, that would be acceptable. We probably need to set a review hearing. And at this point, I don't know that we should set it less than a month away to see if that evaluation is done. So that would be May 11th. And I feel it's important for the court to check in to see where we're at on that evaluation, make sure we're moving forward. So let's come back on May 11th for another review. And if we have the evaluation, then we'll probably take, based on what it says, we'll take a look at the current visitation schedule, and we might make some changes at that point.
Okay, Your Honor, I do have a little bit of concern. I mean, I don't have, any hand in ensuring that Mr. Estrada and Ms. Height are able to put their input in with this evaluation. And just due to the nature of how long things have taken with me and, the people that are administering it and the back and forth of the information, I personally am concerned that neither of them have been reached out to, though I have provided all the information I can on my end without overstepping or making inappropriate contact, or for example, filling out the forms, release of information, adding them to this. And I do have a little bit of concern, and, it gives me a little bit of anxiety to know how long this is taking and knowing I'm doing what I can, but then also I don't want it to come to the next hearing and sound like it's just I'm making excuses or dragging this out. So I just hope that they're able to be contacted as they're needing to be, and that, on the end of the evaluation, that they make sure that that happens.
Okay. All right. Thank you for that. Mr. Estrada, any questions?
Yeah, Your Honor. So when we had the temporary parenting plan that was in place prior, that was 50-50. I was paying child support to Miss Miranda. Now that I have primary custody, I don't receive any support from the other side. And obviously the financial burden is much heavier having full time. Is that something that can be addressed by the court, or do I need to submit another motion?
It sounds like Ms. Powers may be addressing that from the Child Support Division. Let's hear from her. Okay.
Thank
Go
you,
ahead.
Your Honor. Our office has entered a notice of appearance, and we're planning to be involved with child support. It was not noted on the docket today for child support, so I did not think the court was addressing it today. But certainly, we're happy to bring a motion to do a temporary child support order if the parties
Is
are
the
in
child
place.
receiving state funds?
The child's on state medical in this situation.
Okay. So
Oh, sorry.
probably we could look at a child support order. Mr. Estrada,
What I would request is if the court's going to look at child support, can we do that when we come back in a month to review? That'll give me some time to get in some updated worksheets.
we can, I don't think the current visitation schedule is going to be the permanent one, and it may be helpful to know where we're going to go on a permanent basis before we look at that. Let me ask, go ahead, Ms. Power.
There was an administrative order in place requiring the father to pay child support. CCS stopped collecting that in January when custody changed.
Okay. Let me ask the parties to do this, and I don't know if you're both working. Would you turn in the last 3 months of pay stubs and file it with the court? The court would need that in order to address child support. So
Yes, Your Honor.
just go ahead and file that, and then I'll be able to look at that prior to the next hearing, and we'll take up that topic then. Okay.
Yes, Your Honor, I'm happy to submit anything. I do have the state medical for both my children that are, fully active and accessible to Mr. Estrada. So we're both able to utilize that in reference to Sebastian, so that he does have that health coverage. As far as support, I'm more than willing to do whatever I can. I mean, my primary motivation is for the kids, and that's what my efforts are based from. I mean, I'll be honest, I highly doubt that there'll be anything awarded as my income is so low in comparison. But I'm more than happy to do whatever deemed necessary for my end. So I will go ahead and get my financial documents in to the court as well.
Okay, thank you. That would be helpful. All right. With that, we'll come back on the 11th. Ms. Height, did you want to say anything else?
Yes, Your Honor, I would just like to reassure Ms. Miranda that in my experience, typically, I wouldn't be contacted for collateral information from an evaluator until she's really in the evaluation process. So when she's this far down the queue, it's not unusual to not have heard from them. So I think that's a concern she can set to the side. I think they've got their system, and that's just how it works. So the fact that I have not been contacted is not concerning to me, and I hope it is not to her.
Okay, thank you. I appreciate that.
Okay, thank you, everyone. I think that's it on this case. We'll see everybody back here on May 11th. Okay.
Oh, I have one more question. I'm so sorry, or one more piece of input.
That's
I
fine.
do not utilize the setup daycare anymore that was established previously from my job because I work for a daycare center. But I also have through me, his childcare is covered through me as well, based off of my income that Mr. Estrada utilizes. So I'm not sure if that is helpful as far as support and that, or, to consider for child support moving forward. I haven't utilized it since probably September of 2022. But it is open and active and being paid for Sebastian, and Mr. Estrada utilizes the daycare.
Okay, would you, I don't want to address that right now. I don't want to get into a discussion about it. If you
Okay.
could submit a declaration explaining that, and then we'll take it up on the 11th, okay?
Okay, thank you.
All right,
Your Honor, can I speak?
okay, sure. Go ahead.
Just
Mr.
so we're all on the same. It was being covered by the state, but that has ended. I pay out of pocket now for daycare.
Okay.
I can provide, I'll bring on the 11th.
And why don't you bring that information on the 11th also, okay? You are, okay, good. Okay, thank you, and you're free to go.
Thank you.
So this is a motion for adequate cause. The final parenting plan was entered, I believe, on August 23rd. But that was by default, is what I see. And that provided primary custodian was Tyree Jones, and I think there was a concern that the child may not be with him. So I'm going to let Ms. Allwine speak first, and then I'll go to Mr. Jones, and then we'll decide how we're going to proceed. Okay. Ms. Allwine, do you want to go ahead?
So I went to file a parenting plan and I was told that there was already one entered. I was never served paperwork for that parenting plan. That's why Mr. Jones was awarded custodian, but she's been in my care for the last year and a couple months since we had the restraining order. I'm asking that she not be removed from my home, and that we somehow come up to an agreement on visitation with Tyree Jones.
All right, thank you. Mr. Jones, any response?
Truthfully,
I'm not hearing you. Why don't you try that one more time?
I said truthfully, I don't feel like my daughter is safe being there with her. From like all the accusation I didn't heard, like her dad overdosed twice in front of my daughter, and she leave her there with him, and they play outside by themselves. Nobody watch them. So it's like I feel like she's better with me, because at least I will watch them. And in my parenting plan, I give her Friday from 4 till Sunday to 4. And it's like, I'm not a bad parent, and I'm not trying to put the blame off on nobody else. And I'm not trying to take my daughter away from her, but I'd rather her be with me, where I know she's safe and she's not out running around with nobody watching her.
Okay. Have you seen your daughter since August, when this parenting plan went in place?
Last time I seen my daughter was after the parenting plan was like during the summertime.
All right.
It's been over a year.
All right. And you've had her that whole time, Ms. Allwine?
Yes, there's been a restraining order since February of 2021.
How long was that entered for? Do you know?
That was
Actually-
entered for 1 year, and then I got awarded another year due to trying to finalize the parenting plan. And there's a restraining order, I'm sure you can see in the paperwork, that Mr. Jones had pulled a gun. Had pulled a gun on me because I took too long at the minute mark trying to pull out some money for him. He's been violent when I've asked him to leave the home. I don't feel like he's safe to have Kalia. He doesn't have his own home. I went to the Oxford House to try to serve him paperwork, and they're like, he doesn't live here, ma'am. Yes, my daughter misses him, but I don't feel that it's safe just to throw her into another situation that she's unfamiliar with. She's only 3.5. All she knows is mom. And my father doesn't live with me no more, sir. I have child state care. I just got approved for it.
So I'm going to approach this a little bit differently. Right now, there's an order of default in a parenting plan that has Mr. Jones as the primary custodial parent. Ms. Allwine has indicated she was not provided that paperwork. So I think as a matter of procedure in this case, the first thing that I think we need to do is have Ms. Allwine bring a motion to set aside the default. And I'm sorry, that's legally technical, but essentially you would bring a motion to set that aside with a declaration explaining that you were not served with the paperwork.
I believe I did so, sir.
I think you turned in a declaration, but there's been no motion
Oh,
to set
okay.
aside the default.
Okay,
That has to be heard. There needs to be a notice of hearing, and Mr. Jones has an opportunity to respond to that. If it's set aside, then we're basically back to square one. The court would likely appoint a guardian ad litem to investigate the situation and then enter a parenting plan where both of you are involved. But the first thing we have to do procedurally before we get to that point is determine whether the default will be set aside. I'm not prejudging that, but I'm just saying that's the next procedural step that we need to address. So what I would suggest, I'm not going to set another hearing. It's going to be in Ms. Allwine's responsibility to bring that motion, set the hearing date. It would be on this docket a Thursday at 9 and have that motion heard. Mr. Jones, you would have a chance to respond. Okay. And then let's figure out what happens with that motion, and then we'll decide what we do going forward. Okay.
so I'm looking for the motion to default. Is that what you're
Motion
saying?
to set aside a default.
Okay, motion to assign the default. Thank you.
And it's important that that be brought within a year of the original order. So the original order was August 23rd. I hope you bring it right away, but you need to bring it by August 23rd or you lose some rights if you don't.
Okay.
Okay.
Okay, thank you.
All right, so let's do that with that case, and I'll probably see you both back here in a few weeks. So there's a motion
Thank
for
you.
temporary orders, a motion to appoint a guardian ad litem, and then the motion was to terminate a restraining order. I think procedurally where we're at is there's a temporary restraining order, and we're here today to actually hear the motion for the restraining order and however that is entered, if it's entered.
Yes, Your Honor. Then the motion is for the hearing on the 27th. It just, all of it kind of flowed together.
Okay. I think we need to hear the evidence on the restraining order first. And we typically will do that by placing the parties under oath. So Mr. Miller, I believe you're asking for the restraining order. So I'm going to place you under oath and hear from you first. And then Ms. Young, I'll place you under oath and hear a response. Okay. All right. So Mr. Miller, you want to raise your right hand, please? Do you swear or affirm to tell the truth in these proceedings?
Yes, Your Honor.
Mr. Miller, is everything that you stated in your request for a restraining order true and correct?
Yes, Your Honor.
Okay. Tell the court why you're seeking a restraining order against Ms. Young in this case.
Well, let me see. Like, how do I explain this? I've had my daughter for the last, 2 years being down here. And I don't have my paperwork right here in front of me. So I've had my daughter down here the last 2 years of me working down here and me being in Cowlitz County. Taylor has DV stuff going on up there. She's got protection orders against people up there. And I need to make sure that my daughter is safe and in a good personal dwelling and staying in school. And she's not in any chaos environment. Like Miss Young had an incident up there at her personal dwelling where there was a DV case. I put all that in there, I believe. She has, I believe that was her boyfriend or something like that, whoever it was up there. But there was a domestic violence case reported. So she had to go get a restraining order on her ex, whoever named Drew Surratt or something, you know, and my daughter's seen that. And my daughter brought that to my attention, not to my attention, but also a teacher at school. And the teacher is called the CPS worker, and the CPS worker is now doing her job on that.
Okay, so you're saying your daughter witnessed the domestic violence between Ms. Young and this Drew person?
Yes, she had witnessed something to come back to me to tell me and to bring it up to a teacher at school, to where the teacher thought that that's what was going on in our home, which I had to correct that. Me and my girlfriend had to correct that. Okay. To where I had to go and hunt down police reports, evidence of the incident that my daughter was talking about. And it is an actual legit event that happened at Miss Young's dwelling. Yes, that my daughter has knowledge of. I mean, she's 7. She's not gonna lie. I'd be like, she's not gonna lie about big stuff like that. She might lie about taking the candy out of the drawer, but she's not gonna lie about something like that.
Well, and you were able to document it with police reports, it sounds like.
Yeah, I submitted everything to you guys.
You don't personally have a fear of Miss Young at this point, is that right?
Oh no, I believe she would come to my house and start a whole ruckus. Absolutely, I do.
As relating to your daughter, though, right? Or do you feel threatened by her personally?
As she would harm my daughter? Yes, by not giving her medication and stuff like that, and not bathing her. All of it. Absolutely, there's harm there. Absolutely, there's fear there. Now, there's no doubt about it.
Okay, I guess I'm just wondering if you personally feel that you are at risk as a result or relating to Ms. Young.
Yes.
Okay. All right. All right. Anything else?
1 moment. Oh, okay. So yeah, she has assaulted me previously. You know, like in the past, if you guys, I put that in there too.
Yeah. All right. Thank you, Mr. Miller. You'll have a chance to respond to Ms. Young when after she makes her statement. Ms. Young, you want to raise your right hand, please? Do you swear or affirm to tell the truth in these proceedings?
Yes, ma'am.
All right, thank you. You've heard Mr. Miller, and I assume you read his petition requesting a restraining order.
Yes.
So how would you like to respond?
I would like to, I 100% disagree, because what he's talking about, the domestic violence, happened when Malaya was not there. She's never seen anything. She's never heard me and Drew yell. She might have, I'm honestly being honest about, she could have heard me over talking about something, but she's never witnessed anything. And
That's documented in the police report.
it's documented in the police report, and she was not there that night it happened either. Also, the restraining order, there's now one, and I thought it was in the beginning, because from history with Cameron, as soon as the police were involved, there was a restraining order in place. Well, when the police came, and the next day a lady called me asking if I wanted to press charges and everything, and that he was gonna have court on a certain day. So I thought of the impression there was already a restraining order. Didn't talk to him, haven't nothing. Then I get an email after we already went to court from the lady who called me from the court stating that he's been picked up and he was in custody and that there was a restraining order. And so that's where we are now. But my kid has never seen domestic violence and has never seen me and Drew fight either. But she's seen me and her father fight.
How long ago was that?
Like last year, like when we've been in contact, me and Cameron can't be in the same facility without there being issues. But as soon as that happened, I let it go. I've had domestic violence in the past from, you've read the reports from Cameron, and I have not had contact with you ever since I saw those red flags, have not been involved since. And he never lived at the house.
You haven't seen your daughter for a few months now?
Yeah, about a month now.
About a month, okay.
And this was right after the last hearing. And this was right after the last hearing. So I think it's in retaliation because he didn't get what he wanted. I've done everything that they wanted. I have my own place. She has her own room. I've done everything. I'm in the best point of my life now than I've been in my kid's entire life. And he's not letting me be a part of her life. And that is the problem. And he's the one with the warrant out for his arrest. What if he gets pulled over and my kid's in the car? Where does she go?
Can I state something, Your Honor?
Yeah, I'm gonna give you a moment here. I'm just looking at the temporary parenting plan. Just give me a moment. Ms. Young, it looks like prior to this temporary restraining order being entered, you would see your daughter Friday to Sunday.
Yes.
And then I know I entered an order requiring that you provide the correct amount of medication for her.
Yes.
Okay. And then the temporary order on the restraining order was entered and that stopped those visits, right?
And I missed her for Easter. I didn't have her for my weekend and she missed my dad's funeral.
Okay. All right, I'm going to give Mr. Miller a chance to reply.
Okay, so I want to put on the record that there was another court date that she missed just before this one. So I want to put that on the record because I'm pretty sure that the judge put on the record that she wasn't there. And then also, I don't have any DVs. Okay, I want to put that on record too. Miss Young has DVs. I want to put that on record that she pepper sprayed me and my daughter, you know, so I don't know what she's talking about, not having no DVs. The city of Centralia put a restraining order on her against me with my daughter. I want to put that on record. Okay. And then, you know, I don't drive around with my daughter in the vehicle. My girlfriend does that because I drive all day at work, you know, and also my warrant status has nothing to do with Cowlitz County. Okay. And I haven't been in trouble with the law for over 3 years now going. And I've been doing pretty good working down here in Cowlitz County and doing tree work and stuff, you know, and my daughter's been doing pretty good down here in school, you know. The other thing is while we're all under oath, okay, Taylor's declaration is pretty false advertisement. I want to state that.
In what way?
How she says that there was no domestic violence in her household with that Stewart guy. You can read her declaration and then you could go and read the legit police report and they won't add up. And then you can also go and read Melicia's police declaration, and she'll state that there was never Drew has never hit her physically or anything like that. That's false because Melicia states to the police that Drew hit her the day prior. And then Rhonda's allegations, those are actually pretty wrong too, because there was recently a new guardian ad litem out of Lewis County, I believe like 2 years ago, that Rhonda stated a whole bunch of other stuff too. And just like Miss Young, how Miss Young states that she's in fear for her life or whatever with me and blah, 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 blah. She actually tells the guardian ad litem in Lewis County that she's not. And, you know, and that we're co-parenting and all this and blah, blah, blah. So she's really out for a reach, it kind of sounds like, you know, and I'm pretty sure I put in messages, I submitted messages stating how I didn't force Taylor to sign a parenting plan, like a mutual parenting plan between us, because she went to a notary and had it done herself. Just like I went to a notary and I had it done myself. She also gave power of attorney and custody over at a time to my sister and signed the exact same kind of paper that me and Taylor came up to sign. But the one with my sister, I did not sign. You know, that's the thing. All of a sudden, Taylor wants to sit there and say that I'm out for like retaliation or whatever the heck she's trying to say. No, I could care less about that. Okay. It's about my daughter for one. So how she's like, she was not here at the last court date. I want to state to that. So she's like coming in and out of it.
I saw that in the court record.
Thank you.
Your Honor. I was aware, I thought the court date was on the 31st.
And you had already filed.
And I already filed my response.
Oh, she was there.
All right, we're not gonna.
The judge
in court.
asked me, Your Honor, the judge asked me that day on the court date, did Miss Young know about it? And I looked at him and I said, I'm not sure. Is this a court date that I sat or did you guys sit? Because if you guys stated it, then she most definitely knew about it. And he went back and he looked through his computer and he looked at me through the monitor and says, you're right. We set this. She absolutely did know about that.
All right, let's focus on the restraining order issue. My focus on this decision is I want to make sure that the daughter is protected. And so I'll acknowledge that there's in 2022, there was a temporary parenting plan issued. Apparently the parties followed that for a while. Then they came before me because of an issue relating to the administration of medication. I made an order relating to that. Apparently there were visits going on certainly into 2023. And then recently, Mr. Young has filed for another restraining order. He's provided evidence to the court of police reports that suggest that there was domestic violence occurring in Ms. Young's life. And that raises a concern in it, in my mind, supports a limited restraining order. And it's going to be limited as to time. One of the other requests by Ms. Young is for the appointment of a guardian ad litem. Mr. Miller objects to that, but given the allegations of the parties, the concern about the domestic violence in Ms. Young's life, I think she has some concerns about Mr. Miller. A guardian ad litem is absolutely important in this case. So I'm going to enter a restraining order that will prevent Ms. Young from seeing her daughter. I'm going to enter it for up to 90 days. It may be that less than that, I'll change it. I also want her to be able to have telephone or video contact with her daughter twice a week during that time. And I say up to 90 days because I'm not sure how long the guardian ad litem report will take to generate. That could take a while, but if it can be done in 60 days and we can make some decisions, then probably simultaneous with getting that report, I would lift the restraining order and we would look at another type of parenting arrangement. Well, let's take care of appointing the guardian ad litem at this point. So what we usually do is give 3 names. And if you happen to know any of these parties, you have the ability to strike 1 name. So the names are
Twyla Corey, Keith Lawrence, and Heather Call.
All right, so I'll repeat that. It was Twyla Corey, Keith Lawrence, or Heather Call. Do any of the parties know any of those folks? Okay. All right. So typically then we would appoint the first person on the list. So that will be Twyla Corey. I will give her your contact information and then she will reach out to both of you and do an investigation. Initially, the order will require that you both pay half of her costs. If you're receiving state assistance or you cannot afford her costs, you can file a declaration with the court and I can consider that and potentially have the county pay for your half of the cost of that. Okay.
Can I ask something?
Sure, go ahead.
Okay, so in Miss Young's part, she did state that like I pay her portion. Yeah, how you just stated that like the county will pay her portion. That's correct, right? Like I'll pay my portion, but I don't want to pay her portion.
If she probably asked for that, I'm not ordering that, and I hardly ever order that. I think both parties need to have some interest in the guardian ad litem, and I think having one party pay for it gives the other party a chance to say, well, you know, since they paid for it, the guardian ad litem is slanted their way, and I don't want that to ever happen.
Okay.
So it's very rare that I have one party pay the whole fee.
Your Honor,
But if Ms. Young cannot afford her half, then she can again file a declaration, and I can consider it.
Your Honor, we do have a hearing coming up on the 27th where we filed a motion for an amended parenting plan. That's where we were going to address the guardian ad litem. However, it is very restrictive to have no visitation and phone calls when this domestic violence did not occur when the child was there, as noted in the police report, and never was on the lease. Mom should have some visitation, even if it's at her mother's house, where the child isn't being restricted from the mother. In light of this other hearing coming up, it does take a long time to get a guardian ad litem, and we do want a guardian ad litem to be reviewing everything because there is serious history of domestic violence and criminal events in this case. There's manipulation.
Why is she
And there is
talking? I thought she was
definitely
gonna say-
Mr. Miller, just hang on.
There
Oh,
is definite retaliation because the motion that he filed was directly after you denied him his contempt. And so she hasn't even had time to have time with her daughter. She should have some visitation, even if it is supervised, if that's what you want to do outside of her home.
Because I can stay at my mother's on my visits, and that's surrounded by my grandparents and her. I don't have to be in my home, but I can't go not seeing my kid.
Mr. Miller, any thoughts from you on?
Yeah, I got a lot of them. So for one, I got a question. Is that lady a lawyer or just a legal technician?
She's a legal technician. I'll let her speak.
Is she allowed to speak? Because
She is.
so when I last looked them up, they weren't allowed to speak. They're just there to do paperwork to help you, not speak.
All right, let me ask.
So, okay, so the other thing is like, yeah, I'm not okay with any of that because her grandparents and her grandmother, they all talk bad about me too. So, and they still allow Taylor to take Malaya places, even if the courts said no. So no, I'm not okay with that because that's happened in the past.
All right, here's my concern about, I guess what was just indicated is, the record that I've looked at on this motion shows that there is some domestic violence that's affected Ms. Young. And that could affect the daughter. And I need a guardian ad litem to look into this before I feel comfortable making a change at this point. So I am not going to order supervised visits at this point. I think if a guardian ad litem looks at this and even before the report is issued indicates that would be safe, I'll consider it. But at this point, I'm going to have the two either telephone or video visits until we get a guardian ad litem reflection on this case. Do we need to set specific dates for the telephone and video visits and dates and time, or is that something?
I would like to at least do one video call where she can watch Malaya at practice, please.
At practice, meaning sports
Like
practice?
Yeah, softball practice.
Well, how is she going to be able to talk to her then? I mean, the whole purpose is for her to communicate with her
Yes, that's
daughter.
right.
If you want to Zoom her in or FaceTime her in to watch her practice, that's great. But I think there needs to be two times where Miss Young can have a conversation with her
Yeah.
daughter.
What do you got? I mean, yeah, any day that's okay with her. Malaya is at school from 8 to 4, and then after that she's home. Malaya's got softball practice from on Mondays and Tuesdays at 5:30 to 6:30.
Ms. Young, what dates would work for you?
Thursday, and I can do it anytime.
For the first game.
Okay, so Monday and Thursdays at
I think Monday, what time?
6:45.
6:45, 5 o'clock.
Let's do 6:45 because she's at practice, I think 5:30 to 6:30. So-
Next Monday, is that the 17th?
I believe so.
That's going to be Malaya's first game at 6 p.m. to 7:30.
Well, there may be dates that get in the way, so let's say.
No, that still works for me. It's fine. It still works.
How about Monday and Thursday at 7 p.m.? And if the game gets in the way, then it will be whenever the game is over and she's back at the house.
Okay.
All right. I still want it to occur on Monday and Thursday.
Yes.
All right.
Monday and Thursday at 7 p.m., Your Honor.
Let's do 7 p.m.
Okay, thank you.
For how long?
And for as long as the daughter wants to talk.
Okay.
And Mr. Miller, you're not to interrupt that. You're to provide a space where she can talk to her mother on her own. Okay.
In private?
Yes.
In a room is fine. In private, I don't want the child to feel like somebody's looking over her shoulder.
Okay.
Okay. All right. I'll do a bench order then. In fact, I'll appoint Ms. Corey. Let's set a review. Well, we have a hearing coming up on the 27th.
Yes.
Okay. I'll just see everybody back here then at that hearing, and then we'll set a review out from there.
Okay, thank you. Your Honor.
Real fast, his girlfriend is on here and she's not involved in the case. Is she allowed to be on here?
Well, she can't participate. I guess if she's listening in,
She's just
I'm not going to object to that.
okay.
Then she needs to be in his camera.
All right. There's a motion for adequate cause. And just one moment here. I want to pull it up on the computer. All right. That is brought by Mr. Alton. So why don't I hear from Mr. Alton on the motion for adequate cause, and then I'll hear a response from Ms. Keith.
Yeah, that's for the email from J. Opgrand and from CPS, correct?
Well,
I put it
March 16th, you filed a motion for adequate cause to change the parenting plan.
yes.
And
there's been a lot of stuff going on. Landon has not attended school. I haven't seen Landon in months. I've attempted several times to make contact with Landon. I messaged him on Facebook, and everything was fine up until I served Ashley paperwork. And since then, she has tried to alienate myself and my family from land life. I filed paperwork proving in Ashley's response to my papers that I filed that her response is basically an entire lie. I have an email from J. Opgrand stating that there has been no reports of Landon ever being bullied at school. As of yesterday, they unrolled Landon from Mount Solo Middle School because he is at 20 unexcused absences. There was one call right before spring break, and I find it very coincidental that the call was after I served Ashley paperwork. Now she's trying to go in and make steps to get Landon enrolled in homeschool. But up until I served her papers, there had been no attempts, and he was not attending school at all. Ashley states in her response that she thought that I grew up, and so she was going to give me a chance with Landon, which that is all a complete lie. There's a Kelso police report from Judge Basher that he returned in to the Kelso police detectives because of what had happened in this case. Ashley faking a paternity test that she signed under the perjury of law. And then now she's signing a response basically saying that none of this stuff had happened. And she signs that saying that this is a legal document and she's not lying, but there's several instances where she is lying. There's also a statement from Wayne Anglin, who is a counselor that from Ashley's previous custody case with her son Eli. And the counselor states right in the bottom of it that it appears that Ashley is coaching him to lie about everything bad that happens at her home. I submitted messages between me and Landon that it's very apparent that it's not me and Landon talking. It's Ashley trying to get stuff for her court case. And that just goes to prove that she's coaching Landon and is manipulating Landon through this entire process to alienate me from his life. Me and Landon have a great relationship.
When did you last see him?
I believe it was in September. There, right after I served her the paperwork for the decision to decide parentage.
And
Before that, he did not show up.
you were before me on the protection order, I remember. And so you and Landon have been texting to some extent.
Yeah, I talked to him, ask him how school's going, tell him I love him, ask him, hey, when are you going to come see us? There was a few times when we were at softball that he would, because they lived in the apartments right in front of the softball fields. We saw him at the softball fields a couple times. My mom has made attempts to have visitation with Landon. My mom and Landon have a very great relationship. My mom supported Landon and been there for Landon. Since Ashley falsified the paternity test and the truth came out, my whole family has been very close to Landon. His cousin, I submitted pictures of him and his cousins at the beach together. They play Xbox games all the time. They stay the night at each other's houses all the time. And since the paperwork has been served, Landon's attitude is completely changed, and it's 110% because of what Ashley is doing to him. And my father is a registered sex offender. She brought that up. I wasn't able to submit it, but I do have an email from his counselor stating that there are safety measures in place. He can see his grandkids. My dad does voluntary counseling. He has not been required to be in counseling for the last 2 or 3 years, I believe, but he still maintains going, and I've never left Landon alone with him. He's been around my dad a handful of times. A couple of times with Ashley, when Ashley and I were together, we met my dad up at Chuck's Grocery, and he helped us out to pay our rent for the month. And Ashley was there. She was talking to him, and now that she needs stuff for court, it's not okay. And it's getting thrown in as something that she has nothing. I've been a great dad. I've been there for him. I've done as much as I can for the time given that Landon and I've had together. And Ashley is the one that took those years away from Landon and I when she falsified a paternity test when he was 2 years old. And she took that time from us and now was trying to make things right. But now that there's serious matters in the case of Landon's protection, his mental health, everything, she's trying to get everything and anything she can to use against me. And
let me ask a question. Is your mother and your father still together?
they're divorced. They're civil with each other. They talk almost daily.
But they don't live together.
No, they do not.
Okay.
They do not live together. Yeah, that's
Okay. All right. Mr. Alton, you'll have a chance to respond, but I think I'd like to hear from Ms. Keith at this point.
Okay. So first off, I've never been okay with his father ever. He would call my phone and I would ignore him while he was in prison. We did meet to go borrow some money from him because Garrett would refuse to work as always. So we went and had him help us out. And I believe Landon literally only said hi if he was even there. I can hardly remember that.
Whatever I do, I'm going to prevent the father from seeing the child.
Okay,
That
thank
might
you.
change after a guardian ad litem report, but I'm not gonna, we don't have to spend much time on that issue.
Okay,
I'm not
thank
gonna
you.
allow it.
Also, I've already explained that Landon is being homeschooled. I don't know where he's getting his information again. I've been planning this since before I took him out of school. He'd been begging me. I let him stay home a couple days while we were trying to figure it out, and we talked it through. And I still haven't turned it in. We're moving and stuff, and it's just been really hectic, and then the court stuff. So I am turning that paperwork in. I actually just talked to somebody that texted me yesterday, and I told them that I would get it in as soon as possible, and they were completely okay with it. I also spoke to the detectives about the falsified paternity test. That thing is completely over. It's been over. I did have the opportunity
You
to
accept at this point, Mr. Alton is the father.
biologically, but not legally. He has a legal father that is not Garrett. So I was going to actually ask for.
What do you mean by that?
He has somebody on his birth certificate that is not Garrett, and so that parentage stuff, that it has to be a void. He cannot do that. We tried to talk to lawyers. He had to adopt Landon, so he has a legal father that is not Garrett.
Who had to adopt Landon?
My ex-husband, or well, Garrett had to adopt Landon because my ex-husband
You're saying
is.
Mr. Alton as the biological father has to adopt Landon
Yes, that's what the lawyers always said.
because you put the wrong father on the birth certificate.
Yes, because it'd been too long. Garrett got into heroin and stuff, and he wasn't around.
All right, well, the court has entered an order indicating that Mr. Alton is the father of Landon. That order is what's going to stand. And he is legally the father and has all the rights of a father.
Okay, but I didn't get served a court date. I got served half the paperwork, and she told me she would give me the rest of the paperwork. So I wasn't even informed of a court date for that.
Well, there's an order entered by Judge Hahn establishing that Mr. Alton is the father. If you want to challenge that order, then there may be ways to do that. But as far as this hearing is concerned, I'm going to accept that Mr. Alton is the father, and I'm going to make decisions as if he's the father.
Okay.
So if you have concerns about Mr. Alton, you can tell me, but I'm not going to entertain the argument that he doesn't have a right to see Landon.
Okay.
All right.
Okay.
So you haven't, well, Landon hasn't seen Mr. Alton for some period of time.
Yeah, he chose not to. I've never once told him not to talk to them, even when Garrett's mother lied, because they have a very serious issue with lying. And so she lied to the GAL. And
but if it was his choice, according to you, then do you have any problem with me ordering visits between Landon and Mr. Alton at this point?
Absolutely. That will be completely detrimental. Landon wants nothing to do with him.
Okay.
Right here.
Do you want me to go get him from his room and hear from him?
No, I don't want to do that. I don't like to put children in between their parents.
I wouldn't either, but he cries and doesn't want to go there. And I'm getting told that they're taking him from me. So it's kind of a big deal.
This is the same thing that Ashley pulled with Brock Jenke in their case.
Okay, Mr. Alton, I do want to hear from you, but I want to make sure I've heard everything Ms. Keith wants to say first, okay?
That's nothing like that case. Brock was through the GAL from Keith Lawrence. Brock had been abusing mentally and all of that and started to get physical with my son. And so when we went to court, he was trying to take both of my kids, and knowing Landon was not his, I ended up getting him away from him, and he had the right to choose too. And he went, Garrett actually got mad that he would go see him. Garrett was the one that put the strain in between Brock and Landon. He refused. I probably have messages that I could send you later or something, but I don't trust him. I know that he has drug issues with heroin. I know that he freaks out all the time. He was horrible to me while we were together all the time. Landon has no relationship with him. He came home running from the park, which he says that he was talking to him while they were playing softball, came home, locked the door and said his dad was here before I got served the paperwork the first time. He does not want anything to do with them. They harass him. They bully him. They talk about me. They talk about how they got Eli taken away from me. Like it's completely, it's a hostile environment, and he's not that kind of kid. Like he can't handle that stuff.
Okay, I'm getting close to knowing what I'm gonna do. I'm gonna give Mr. Alton a chance, about 2 minutes to respond, and then, I'm gonna tell you what we're gonna do going forward.
Okay.
Mr. Alton?
Yeah, so I just find it very odd that there's a GAO report from the original case that says that Ashley states she's so sorry for what she did. She was
I
in
am
the
sorry. Sorry.
Ms. Keefe,
Again.
thanks.
you know, she seemed like at the time when there was something that I could do about it, she was very sorry for what had happened. And now that things are coming out and Landon, you know, I know that Landon loves his mom and I know that Landon loves me as well. There are serious matters that are going on at Ashley's house. This whole thing that she's concocted is just, it's insane. I mean, she lied on a paternity test and took me away from my son and comes back and tells me that she's so sorry for what had happened and she wants to make things right. And we went through and we filed an original decision to decide parentage with Brock on there, and that didn't go through. But Ashley, it was the same documents that went through for the decision to decide parentage that got approved. And instead, the first time Ashley, she signed the document saying that she was fine with it. The courts, that case was left open because I couldn't do much on it. And so the courts actually ended up closing that case. I tried to find where she signed off on everything. She knew what was going on. She is very aware of what's happening. She knows the things that are going on in her house are not okay. Landon not attending school is not okay. Her, you know, I was a good dad. I helped her out as much as I can. I've given her money to pay bills, get food for her kids, and everything. And I never once asked for a penny back. I was there to help her when she needed it. And now that things should be getting made right, she wants to revoke everything and turn me out to be this negligent father, which I'm not. I love my son very much. And I just want to see my son and get him back to where he was a year ago when Ashley and I were co-parenting well. He was going to school. His mental health was great. He needs to see a counselor still. And I want to request that we get him into counseling as soon as possible and get him enrolled in school as soon as possible as well.
Okay.
That's all I have.
I appreciate it.
Garrett has never helped me with a single thing.
Ms. Keefe,
Sorry.
I need to make a decision here, okay? All right, so the motion is a motion for adequate cause, which usually is brought to change an existing parenting plan. But in this case, what we have is a judgment by Judge Hahn establishing Mr. Alton's parentage, but reserving the aspect of the parenting plan that the two of you may have going forward. I see there's some proposed parenting plans put in place, but no parenting plan has been entered. So we don't really need a motion for adequate cause. This case ultimately needs to be set for a trial to determine what the appropriate parenting plan is. Before we get there, I would typically appoint a guardian ad litem to investigate both parties. And their job is to advise the court what's in the best interest of Landon. So I'm going to give you 3 names, and you have the right to exclude one of the names if you want. So the 3 names of the guardian ad litem are, all right, so
that Keith Lawrence be on this case, as he was.
No, I want to strike him.
He knows the case already.
It's a conflict of interest. He didn't even talk to my people in my last court.
You don't have to either. You don't have to state a reason.
Okay.
You can say, I don't want somebody.
Okay. So, I don't want Keith Lawrence.
All right. So if she did, do you know either of the other people, Mr. Alton?
No, I don't. I was requesting Keith because he has already built a relationship and knows Landon from this first case that Ashley, Brock, and Eli were involved in.
I
That was
understand
five
that can cut both ways. And as I said, that for no reason, either of you get to strike one person. So
Okay.
Ms. Keith has struck Keith Lawrence. Then we usually go to the second person, and that's Heather Call.
Okay.
And so I'm going to, and that's KAHL. I'm going to appoint her to be the guardian ad litem. The guardian ad litem will do a report. I'm going to probably check in on that about 2 more times. I'll give you a review date, and then at that time, we'll set another review date. Once the guardian ad litem has a report or is close to a report, then I'm going to have you set a trial date so that you can put on evidence before one of the judges to determine the parenting plan, unless you can agree to one. But that not being the case, then you would have to go to trial. Prior to that, and between now and the first review with the guardian ad litem, I'm not going to order any contact between Landon and Mr. Alton. There hasn't been contact for a while. Where there's been such a gap in contact, regardless of what caused it, usually we need to take some pretty thoughtful steps in order to reunite a child with the parent. And I want some assistance from Ms. Call on how we should go about doing that. So I'm not going to order any in-person visits at this point. Okay. And I think that's how we go forward.
Okay, thank you.
All right.
Is there a
Mr.
way
Walton?
that I can talk to him on the phone?
You've always been able to call him, Garrett.
All right. I will put in the order that your telephone calls are acceptable. Okay.
Okay.
And if he doesn't choose to answer those, is that on him, or do I have to
Yeah.
make him?
Usually we let the child decide whether they're going to talk or not.
Okay,
We don't force kids to be involved.
do anything. Okay.
Okay, but certainly, Mr. Alton, you can make the phone call. Well, I have to give you a review date, and I think we need to go at least a month out. So that will be May 11th.
Okay.
Okay. All right. Thank you both. So,
Thank you.
Judge Evans saw this last time on April 6th and put it over for review hearing. And it's just a little bit difficult for me to decipher from the court notes exactly what we wanted to review today. So I'm actually, Ms. Langford's here, that you might be helpful in letting me know what we're looking at.
So I emailed them the report, but they didn't find it until after the hearing.
Okay, I did read your report.
So they didn't review the reports at that time.
Okay. So part of the reason we're here is so they can comment on your report and your recommendations.
Yes.
Okay. All right. Why don't we start with Mr. Thomas? Do you want to comment on the report?
Overall, I'm actually fairly happy with the report. I, however, didn't receive the link for the parenting class, which I was kind of concerned about finding that.
Okay.
I will resend that as well.
Okay. I did check and specifically searched for Vashti's email as well, and it didn't come up, so I'm not sure what happened there.
Okay. All right, Mr. Nguyen, any comment?
Ultimately, the report added up to everything. The only concern I had was Randy's girlfriend was interviewed, Cynthia Macy, and I have never been around Cynthia. Cynthia has never seen me around Riley other than maybe once at a park, but I've never been to any family gatherings with her, anything like that. And she had stated that that was what had happened. And they've also been dating for almost a year, not a couple months now. So
So some of the facts in the report you dispute, but it sounds like the recommendations you're okay with.
Yeah. Oh, for the most part, yes.
Okay. What I'm able to do is adopt a temporary parenting plan. One way I could do that is to simply say that the court adopts the recommendations of the guardian ad litem. Is that something you both would agree for me to do?
Yes.
My only concern is Vashti had asked me to come with dates that I'd be able to make visits, and I've done that because I am in Job Corps, so I have a lot of rules and guidelines and specifications that I have to follow, as I can leave on weekends, but it all has to add up financially with buses and transportation and getting to and from, because I am 4 hours away. So, and on top of that, I am working towards my certifications for my career and all of that. But I have the last weekend for April, May, and June like cleared, and I have buses and tickets that I can purchase right now to make sure I have that transportation to get to and from. So
I think the concern, you know, the recommendation is first and third weekend. And the concern was there was last minute changes to that, and Mr. Thomas was not able to kind of make plans. So how far ahead would you be able to advise Mr. Thomas about any changes to that schedule?
as of right now, for April, May, and June, I can only leave. The train schedules only line up, and my paychecks and everything only line up, so I could leave the first, or not the first, the last weekend for those 3 months.
Like the fourth weekend then?
Yeah, so it'd be April 28th to the 30th, May 26th to the 28th, and June 23rd to the 25th.
Mr. Thomas, would that work at least for the next 3 months?
I don't have a problem with the May and June. However, April, I have plans already planned out, an invitation sent out for Riley's birthday party because I planned around the original schedule.
Randy Thomas was very much aware that it could change. And as I've missed Halloween, Christmas, Thanksgiving, Easter with Riley, I would like to argue that I deserve to have her for her birthday, and I wouldn't be picking her up until 5 p.m. So he would get the first half of the day with her.
Pick her up at 5 p.m. on Friday?
Friday the 28th, yes.
I've had plans in motion for months since we first got the original schedule. That's why I have issues with this.
Would you be able, well, the first weekend would be the next weekend in May. So you would essentially get 2 weekends in May. Could you move it to the first weekend in May?
I can only leave 1 weekend in May because of my school schedule.
Okay. And you're not able to make it the third because of finances?
Finances and bus schedules and transportation issues. My other biggest concern with Randy is a lack of communication. I try and text him, I try and communicate, but he never replies. Like, I messaged him on Easter and I wished him and Riley both and good Easter. It was in a chat with Vashti, and I asked him for pictures and I didn't receive a response until a few days later.
I responded to you the very next day.
You responded to me on Tuesday when I was supposed to call her.
Yeah, we're not going to argue that at this point. It's disappointing that April has run into a conflict. But at this point, I'm going to accept that Mr. Thomas has made plans for a while, and so that weekend is not going to work. So I guess the first weekend going forward will be the last weekend in May.
I personally don't believe that that's fair, because Randy Thomas has had her for every holiday. He's had her for everything. I didn't get to see her last month because of, originally I had messaged him last month and I had stated that I'm not gonna be able to make my visit until the end of the month again. And he had responded, okay. And as it got closer and I went to confirm again, that's when it became an issue. I have all the messages.
So just a minute. The order I'm going to enter says you get to see the child on the first and third weekend of the month. And
I'm asking for that to be changed.
You want that changed, but when you ask for the change, then everybody needs to accommodate that. Mr. Thomas can't, for whatever reason, whether you agree that his reasons are valid or not, I'm going to accept those reasons. And I understand it may look unfair, but the order itself is not unfair. The reason that it's unfair is because we have limitations on when you can come down. And I'm sorry that's the case, and I'm sorry we can't accommodate the end of May or the end of April, but it will be the end of May, and I'm going to order that Mr. Thomas does accommodate the time at the end of May and also the end of June. And if it has to be once a month after that, and Mr. Nguyen wants it to be the last weekend, then Mr. Thomas, I would like you to make accommodation for that. But Mr. Nguyen, you need to make that known at least a month in advance to Mr. Thomas.
I have been trying, but Randy Thomas does not communicate with me.
All right, well, I'll be looking at this going forward, okay? So did you, Ms. Vashti, did we talk about any telephone or video visits? I think
They were doing, I believe, weekly visits on Tuesdays and Thursdays, I believe, already.
All right, those should continue. Okay. I'm going to set a hearing in June to make sure the May visit occurred. May 29th. That's not what is that? May 29th is Memorial Day, I believe.
I have May 26th to the 28th.
That's all you got. Okay. All right. Well, let's be back here on June 1st. I want to make sure that visit occurred in May. And see if there's any other issues for everybody.
I would like to ask if there's any way that if I could still have her that last weekend, if I just brought her back and dropped her off for the length of the birthday party and then picked her back up. Because I have not seen my daughter in a month.
When's the birthday party, Mr. Thomas?
So all day Sunday is for sure taken. I believe I have some time open Saturday, the afternoon.
So is it plausible that I could have her Friday until Sunday, or not Sunday, Saturday at like 8 p.m. And then you can have her all day Sunday for the birthday party. So I can still spend her third birthday with her.
What time Friday?
5 p.m.
5 to Saturday?
Saturday at like 7:30, 8 p.m.
Goes to bed at 8. Could we do 7?
Yeah, that's fine.
That would work.
Okay, good. Thank you for working together on that. So then the last weekend in April will be the 27th at 5 to the 28th at 7 p.m.
I believe it would be the 28th to the 29th.
I read something wrong. I'm sorry.
Because her birthday is
28th to the 29th. You're right. All right, then we'll still be back here June 1st at 9 o'clock. Okay.
Your Honor, am I relieved of my duties at this point?
Yes, thank you for your report, and I will relieve you of your duties. If you want to submit your fee statement, I'll look at it.
One more thing for Vashti. I also did not receive any links for parenting class.
I just resent them to the both of you.
Okay, thank you.
Okay, Ms. Forrest, can you hear me okay? Thank you.
Yes, sir.
All right, and Mr. Clark, can you hear me okay? You'll need to unmute yourself, Mr. Clark. Well, I'm going to assume you're able to hear us. Ms. Forrest is bringing a motion to invalidate the marriage. And I'm going to let her speak to that. And then hopefully we can get the technical issue dealt with Mr. Clark. So Ms. Forrest, do you want to tell me why you want to invalidate the marriage?
We have never ever lived together. He has his ex-girlfriend, Shannon Spencer, living with him. I have a roommate, and when we got married, we both altered our plans. Like one minute we were talking about my roommates and my friend leaving, and I don't know why he wanted that, but the whole thing was I was supposed to move in, and I told him I'm not moving in with you and Shannon. ever. It's ridiculous. Then he was very abusive. He didn't do any really husbandy things. I've never been taken care of. I pay my own bills. We have separate bills. Right now, I have a restraining order and a case number, which is A23-7688 by Beadle, Deputy Beadle, from him staging, because he stole my arrow and he staged trying to get me put in jail wrongfully by ripping his jacket with the arrow, and called the police on me when I was inside with my professor on Zoom. And I was bone drying on the 10th. It was really raining. And I've just got these so much. The other deal breaker was, I'm sorry, there's all the text. I believe I sent these to you. I don't know if you have the whole thing. I have zero tolerance for drugs. And when he started acting really aggressive and then lying, he literally sabotaged me in the places. We live next door to each other. We don't even live together, but he's got the landlord involved, talking, smack to me. And then, just horrible slander. And I asked him to pee in the urine, and he did, and he peed.
Oh, sorry.
Mr. Clark, can you hear us?
Can you hear me?
Yeah, now we can. All right. Have you been able to hear Ms. Forrest?
Yes, sir. There's one issue that I do
Don't
have.
speak right now. Don't speak.
Okay.
I want to hear Ms. Forrest out, okay?
Okay.
And then I'll hear from you. Ms. Forrest, on your petition, you marked, we currently live in the same household.
No, we currently do not. I live in space 12. He lives in space 13.
Okay, I understand you're telling me you don't, but that's what you marked on the petition. So it sounds like that's incorrect.
Yes, sir.
Okay.
The last time I showed up for court, because he didn't, the judge told me that I had to write a declaration so he could move forward with the invalidation. So when I charged my phone, because I wasn't feeling good that day, I get a message from him, text messages telling me I'm worthless, a piece of shit, I'm a whore. And then what I told him in a nice way is, I'm sorry, I was at court. Basically, we have until the 13th to either work our days out or just invalidate, because I am not going to move in with you with Shannon Spencer. And he keeps bashing
the choice here, I guess. There's the other choice is, if I don't find the marriage invalid, then that means you just go through a dissolution proceeding. You file for a divorce and you go that route. So I guess you're claiming that you were married because of pressure, force, or fraud. Is that right?
No, the pressure was so I was moving my friends into, I was trying to move my friends into another trailer park.
Was this before you were married or after?
No, before.
Okay.
And I told him, because he was really worried that I wasn't going to come back and I was going to move with them. I said, I love you. I'm not going to do that. And he's like, I think you will. I was like, well, one day we'll get married and that would prove love, whatever. And I can't remember verbatim, but I do know that to prove my love, I went ahead and married him early. And I said, and then when we were going there, I changed my mind just because of his behavior and how he was treating me. And he argued with me. He's like, please, I promise I won't bother your friends. I'll leave fag boy and lesbo alone. I will work this out. We'll take our time. And so we constantly tried together to try to make it work, but our lifestyles are too different. And then when he he bought me flowers the other day, which he's so believable. And so I was like, wow, questioning my own sanity. I went down there and we were supposed to spend time, and the flowers were gorgeous. But I wanted to pick out like a song so he could hear it because he was playing the heavy stuff. But I was going to surprise him with a song. He was in the shower. And you know how you go on YouTube, if you get messages or you have messages, when you click it back on the phone, the screen goes blank. Well, I saw all the lies on one thing. It was a very suspicious text. And he was caught with sex toys. And I've asked him, right?
Yeah, right.
He needs to get rid of them. My neighbor, Beth, and he has a panty problem where he steals people's panties out.
Man, that
It's just too much. I
that
don't.
isn't the issue here, really. The question is whether you were pressured, forced, or into the marriage as a result of fraud.
I feel it was a fraud because he promised he wasn't gonna berate my friends or overstress me out, and that's all it's been is pressure with him.
And he said that before you got married?
Yeah, and then just like I promised, I would move my friends, but then we talked about they would be homeless. I even told him that we could work on getting an apartment together. He's never made an effort because to him, which he's read many times in the text, he's perfect. Why change him? But he's always going to drug houses. I'm a psychology student. I didn't bargain for this. Not to mention zero respect. Like,
Okay, let me hear from Mr. Clark, okay?
he set me up and lied about me. I mean, lies all the time about me.
You'll have a chance to respond. I want to hear from Mr. Clark. Mr. Clark, what's your position about the petition to invalidate the marriage?
This marriage is and believe me, is invalid. And Miss Forrest is lying. She does not have a restraining order.
Before we get into all of that, do you agree that I should invalidate the marriage?
Yes, I do, sir.
Well, then that's as far as we need to go. I'll sign an invalidation.
For the record, can I say just that Miss Forrest does not have a restraining order against me? She got served yesterday, and the restraining order against her is active.
Okay, just a moment.
I've never been served.
I'm an hour late on another docket I'm supposed to handle, and we're not going to deal with the restraining order. The only thing before me right now is whether the marriage should be invalidated.
Yes,
Both
sir.
of you have told me you want it invalidated. I will sign that order. I don't have that order in front of me. So Ms. Forrest, you will need to prepare that order and provide it to me. And that would be an order invalidating the marriage and also something called findings of fact and conclusions of law. You can get those from the clerk's office if you need to.
Okay, let me write that.
I'm going to grant the order or the motion invalidating the marriage because both of you.
Thank you.
All right. And that's as far as I need to go today.
Wait, so
have a good day, Your Honor.
What's the other one called?
Thank you.
It's called, and there'll be an order invalidating the marriage and then findings of fact and conclusions of law relating to a marriage.
Findings of fact
and conclusions of law.
Thank you.
Okay. All right. Thank you.
Thank you,
I'll
Honor.
write that order, I'll sign it.